Professor Hawley, I want to start with you. The president's record, this pace of federal judges, put it into context for us. Why is it such a big deal?
I think it's an incredibly big deal because obviously the federal courts are something that survive a president's term. And the federal courts can really make a difference, as you were just talking about in Dobbs. So, for example, President Biden has appointed, as you noted, 11 Black women to the federal appellate courts. In 230 plus years of federal courts, we only had 8 Black women to ever serve on the appellate court. So it's really a historic record of confirmations and nominations that the Biden presidency has really put forth.
In an interview with the Associated Press, White House Chief of Staff Ron Klain said, quote, having a more diverse federal bench in every single respect shows more respect for the American people. And Professor Goodwin, there is, the gender piece of this. There is the race and ethnicity piece of this. There's also the career diversity, right? The fact that you have more public defenders in the mix, that changes the courts themselves.
Well, it absolutely does. And thank you so much for having us both on with you, Alicia. The United States incarcerates more people than any other country in the world, more men and, in fact, more women than any other country in the world. And the fact that we've had a federal bench and also a Supreme Court that fails to represent the wholeness of what America is all about, including the representation of people who have been criminally charged, is itself something that has been a fault in how people have been nominated to our courts, not just the Supreme Court, but also the lower federal courts. And so this is a big corrective. And it's worth noting that we have a constitution where the first 10 amendments, many of them are about protecting people in the criminal justice process. And yet we've not had the federal bench represent that.
Staying with you, Professor Goodwin, because I do want to talk about the article that you wrote. We've talked extensively, you and I, about the fallout from Dobbs. I wonder what you are watching for next, particularly in states where abortion is now outlawed.
Well, it's worth noting there's an article that I wrote a few years ago with one of my former students who's now on track to becoming a professor herself, Mariah Lindsay. And we wrote about the representation of women on the bench and what that means. And so when we're thinking about this, critical mass makes a huge difference. And that is what we see with the Biden administration and the volume of women that are being nominated to the court. It's not enough to just do what would be considered tokenism, one woman here or there, but you really need a mass movement in order to make their ways of thinking, methodology, their clarity come to life. And what we found in a study that we did is that even Republican appointed women to the federal bench are inclined to support reproductive freedom. And so you don't have to just look at the Supreme Court with Ruth Bader Ginsburg or Justice O'Connor, but if you look at federal courts, prior to Donald Trump, consistently Republican appointed federal judges that are women support reproductive freedom. So I think the impact is clear, whether Democratic appointed or Republican appointed.
Professor Hall, I am interested by what we are watching right now, sort of under this presidency. I also wonder if something has shifted for Democrats, right? If the sort of importance of the court now looms larger, not only because of Dobbs, but because of how important the courts were for accountability in the Trump era. I mean, has this created sort of a seismic and permanent shift?
I don't think we're quite there yet. I think one of the major kind of missing pieces to this is the federal trial courts. So when we look at the federal trial courts, the district courts, there are a huge number of vacancies, especially in the South, in the Southern district courts. So take a judge like Michelle Childs, who is on the district court for South Carolina. She's now on the appellate court in D.C. Her space is vacant. So there's 2 Republican senators in South Carolina, and through the blue slip process, they can hold up nominations for the district court. And we are seeing an extensive number of vacancies. So I think before we begin to say that there's been wholesale change and really a seismic shift, we really need to see the pace of confirmations and nominations to the district courts, which make a huge huge exception for many cases happen or are decided at the district court level. Until we see that pace of nominations really pick up in the Southern District Courts, I don't think we can declare it a seismic shift yet, but that's the direction that it's moving in.
Professor Goodwin, before I let you go, I want you to talk to me about the way in which this conversation about reproductive rights has started to become about the First Amendment, understanding the roots of that conversation have been there for a very long time.
That's right. One of the matters concerning pre-Dobbs, and now certainly a glaring problem post-Dobbs, is the way in which the First Amendment, particularly religious protections, has been used and weaponized before the Supreme Court. And sending signals to state legislatures. That is to say that now we must be concerned about the way in which the protection of religious freedoms will impact people's access to contraception, or at least the claims, right? The claim that one has a religious objection to providing and dispensing contraception. The ways in which the First Amendment has been used as a sword to tell librarians that they may not talk about abortion, that they may not help people search the term abortion, the way in which there becomes a kind of weaponization and using the First Amendment to protect the rights of those who are anti-reproductive freedom to the harm of people who are pro-choice, who would say that they have a First Amendment right as well. And so the New York Times piece goes through the myriad ways in which we should be really concerned about the Constitution turning upside down, including the First Amendment protections being limited for those who would seek to protect reproductive freedom and weaponize for those who are anti-abortion.
And lands on the very scary possibility of living in two Americas where the First Amendment is treated very differently in this regard. Michele Goodwin, Danielle Hawley, thank you both, as always.